Hello everyone, and thank you very much for joining in today. It's a warm welcome to our webinar introducing you to the key issues related to copyright and artificial intelligence. My name is Gosia Evans. I'm a senior intellectual property solicitor at Harper James. I have in excess of 14 years of experience in advising in relation to intellectual property disputes and general commercial disputes. Today's focus will be on copyright and artificial intelligence, since these are the issues that multiple clients inquire about. These are very live issues, and I hope today's webinar will be of assistance to you, introducing you to the main points. Today's focus will be on the key concepts related to the basics of copyright law. We will then move on to discussing how artificial intelligence interacts with copyright law protection in the UK. We will briefly touch upon ownership issues and originality issues related to AI-generated works. And we will also discuss the introduction to the current legal position in the UK and the upcoming changes following the government's consultation on AI and copyright. We will also cover recent developments in case law and outstanding issues that will be covered potentially by the new legislation as well, such as protection of image rights. And finally, our webinar will also focus on some basic practical advice for businesses and creators using artificial intelligence tools for the purposes of their businesses. Just a brief reminder, this webinar is for general information only, and nothing within this webinar constitutes legal advice. If you've got any follow-up questions after watching this webinar that are of specific nature, then we very much invite you to contact us. We will start off with saying that there is no legal definition of artificial intelligence, and there is no comprehensive regulation of artificial intelligence as it stands in the United Kingdom. The UK government has taken some significant amount of time to review various options in the context of regulating artificial intelligence and copyright. It's an uncharted territory. There have been consecutive governments exploring this regulation since at least 2019. There have been multiple attempts at creating a voluntary code of conduct following Sir Patrick Vallance's review, which focused on protection of AI and copyright, but these attempts have failed. And the key issue is protection of creative industries worth £124 billion to the UK economy, and balancing importance of this with providing access to copyright protected works to AI developers and AI tools in a way that would enable them to fairly develop them and not fall behind other jurisdictions. Of course, the UK government is informed in their approaches and in the research by approaches taken in different countries, such as in the US, in Singapore, and in the EU. Those approaches vary. Some of them are leaning towards deregulation of protection of copyright and allowing copyright protected works to be used by artificial intelligence tools. Other approaches are a bit more conservative, and they focus on ensuring that copyright owners' rights remain protected and that their works remain fully licensed for the purposes of AI use. The impact of this decision is obviously very significant, not only for the purposes of protecting the creative industries, as mentioned, but also for the purposes of making sure that we have the legal certainty that is needed for AI developers, AI tools users as well, to make sure that every stakeholder is aware of what they're permitted to do and what the risks of use of AI tools are. So in relation to using copyright protected works for the purposes of AI training, it is very clear that copyright protected works are already being used to train AI tools, and this happens worldwide. They're used by AI tools developers. They are input into AI tools by users on a daily basis. The general rule in the UK should be that we should never assume that a work that is being used for the purposes of AI training or for the purposes of AI input is not protected by copyright. It is highly likely that any work that is ever used is protected by copyright. It by no means is the case that works available online are not protected by copyright. It is actually far more likely to be the case that there is a copyright owner, there is copyright protection subsisting in the work. So we should never assume that works available digitally are free to use. In the UK, as a general rule, you need owner's permission or a license to be in place to use third-party works that are protected by copyright. And copyright owners in a situation where the work is being used without their authorization are in a position to enforce their rights, which are set out under the main act regulating copyright in the UK, which is Copyright Designs and Patents Act 1988. And I'll refer to it in this presentation as CDPA. It's important to note that a lack of knowledge that the work is protected by copyright is not a defense to copyright infringement. Copyright infringement is a so-called tort of strict liability, which means that the responsibility to find out the copyright ownership, subsistence and ownership position is on the party who decides to use the work. What is copyright? We talk a lot about copyright and copyright protection, but I think it's important to start with understanding what copyright actually means as a right. We need to understand firstly that it's an intangible right, it's invisible, it's a property right which protects original works. Generally speaking, there are multiple categories of works set out under CDPA, but the four main categories of works that are of interest to most of us are literary, dramatic, musical, and artistic works. Now, for the purposes of obtaining copyright protection, any such work must be author's own original intellectual creation. So it cannot be copied, it cannot originate from third-party sources. It needs to be the author's own original work that is recorded. That means that there is no copyright protection in respect of just ideas or concepts that we have. We need to express those ideas, and it is the expression of those ideas, so our work, that can be protected by copyright. It's important to note as well that copyright is the right that arises automatically. So there is no need to register it in the UK. Copyright lasts between 50 and 70 years from the author's death. It depends on the type of work in question, but this is a general rule. And specifically, we get a lot of questions from our clients related to protection of software code as copyright. And the good news that as long as software code is originally created literary work, it can be protected as such. Copyright in it can subsist as literary work. So that's worth noting. In terms of authorship and ownership of copyright, the author of copyright protected work is generally speaking the person who created the work. If there are multiple authors of the work can be considered as having joint authors. The interesting point under CDPA relates to so-called CGWs. So CGWs are, in other words, computer-generated works. In respect of CGWs that are of literary, dramatic, musical, or artistic type, which are generated by computer in circumstances where there is no human author, the person by whom the arrangements necessary for the creation of the work were undertaken would be considered an author of the work. And the useful thing to know in relation to being an author of the work is that the author always retains rights that are so-called moral rights, which are paternity, no false attribution, no derogatory treatment, etc. In other words, the author of the work has the moral right to be recognized as the author of the work, has the right not to have a different work falsely attributed to his or her authorship, and the right also not to have their works treated in a manner that could be considered derogatory. Is the author always the owner of copyright? Well, the simple answer to that question is no. It does tend to be the case that the author is the first owner, unless otherwise agreed or unless the work was created in the course of performance of employee duties. If it is the case that an employee creates the work in question as part of performing their employee duties, the ownership of copyright in the said work will automatically vest in their employer. It is also possible that the work created by a certain author can be assigned or licensed to another party. In terms of copyright infringement, an infringement involves unauthorized use of a substantial part of the work protected by copyright. And an infringement can take place by way of copying, by way of publishing, or adapting the work without the owner's permission. In terms of ownership of copyright, the owner of copyright is the person who is able to enforce their rights. So the responsibility to find out about the infringement and to then take forward any relevant enforcement action is on the copyright owner. In terms of damages that are available, these involve financial damages and also non-financial remedies, for example, various injunctions or order to deliver up infringing works or order to destroy them. So there are various remedies of financial and non-financial nature available to copyright owners in the event they find out about the infringement. In terms of works created by a human author with assistance of AI, there is always a question mark in relation to who owns copyright in said works. As a general rule, if a human being creates work using artificial intelligence only as a tool, for example, we take a photo and then we use an AI tool to edit a photo, standard copyright ownership rules will apply. So photographs taken by an individual and then enhanced with an AI tool will mean that the ownership of copyright vests in the author of the photograph, so in us. It is always, however, a question of fact, because naturally the question arises, where does the AI tool role start and end in terms of it being a support tool? And there is no blanket advice and no blanket rule applicable here. It will be a question of fact in every case. It's worth noting that there is at the moment no legal option of having a co-authorship situation whereby copyright is co-owned or co-authored between a human author and artificial intelligence. In respect of copyright protection in AI-generated CGWs, so computer-generated works, there is a question as to whether CGWs can even be protected by copyright. And legally, it's not a straightforward question in the context of any work that needs to be original for it to attract copyright protection. So as mentioned earlier in the presentation, there are certain key 4 types of works that need to be original for them to be protected by copyright. And these are literary works, artistic works, etc. And the current originality test requires any such work to be the author's own intellectual creation and for it to involve personal touch from the author. This test is rooted in European Union law, and it's a different test to the test that was originally applicable when Copyright Designs and Patents Act was drafted. At that point, the Act required skill, labour and judgment of the author for the work to be considered original. And whilst the former test could be reconciled fairly reasonably with CGWs, it is not necessarily all that clear how the current test stemming from European Union law would be reconciled with the rest of Copyright Designs and Patents Act in the context of originality requirements for CGWs. And obviously the main point here relates to that human aspects of it and that personal touch of the author. And that's particularly relevant in the context of AI-generated works where clearly on the factual situation, that input from the human author may be very limited. In the context of CGWs and the work created strictly speaking by artificial intelligence, so generative AI output, there are further questions related to authorship and ownership. As mentioned previously, in respect of literary, dramatic, musical or artistic works that are computer generated, the question is, who is the person who made the necessary arrangements for that work to be created that would apply? And the answer to this can be unclear, because this could technically be the person who entered the prompts into the AI tool, so the user, or it could be the developer of the relevant generative AI system, so the person who created it. Legally, it appears more likely that it would be the developer, but again, the question of facts arises here, whereby we would need to look at the complexity of the prompts entered by the user and the scope of input actually created by the AI tool to be able to definitively answer the question in relation to any authorship and ownership of generative AI output. This is obviously an unhelpful position, because I appreciate many business owners come to us with questions related to that output that they are then willing to use. They are trying to understand what rights subsist in it and whether any rights have been infringed. And this is not a straightforward question to answer, and it will be influenced by the upcoming decision of the High Court in relation to the Getty case. I mentioned at the outset of the presentation that the UK government has recently consulted on regulating artificial intelligence and copyright. This consultation closed in February 2025, and we're currently awaiting the government's report on this and the government's decision, which is not expected to be implemented until mid-2026. For context, the UK consultation on copyright and AI involved 4 options. Option 0 was to do nothing and keep copyright protection unchanged as it is. Option 1, the system was supporting introducing a system which would require licenses from copyright owners for the purposes of any and all AI training to take place in respect of copyright protected works. Option 2 supported the idea of allowing a universal copyright exception for AI and data mining. And option 3 was a halfway house, whereby there would be permission to use copyright protected works for the purpose of data mining, and the right owners would have the right to opt out from their works being used for the purposes of AI training. Option 3 is the option that was supported, and it has been rolled out already in the European Union. And initially, the UK government was approaching the consultation with this option being the preferable option. However, naturally, many stakeholders provided their comments into the consultation, and the UK government is currently reviewing them and reconsidering which of the 4 options will be considered most suitable and will be rolled out most likely next year. From our perspective as practitioners, we always say that certainty is the best policy. It's always good for all parties involved to understand what the risks are of using certain works, what is permitted and what is not permitted, and what steps specifically they need to take to make sure that their activities are lawful and they're not infringing on anybody's rights. So this is really the key principle that from our perspective should apply to any considerations, any future considerations on regulating artificial intelligence and copyright. As a disputes lawyer, I know very well firsthand that disputes can be expensive, and the more clarity, transparency, and unified approach can be applied, the better. In the ideal world, we would avoid disputes, or we would end up in a situation where we are in a position to assist the parties to resolve them quickly at an early stage. But of course, we appreciate the situation in relation to regulating AI and copyright is not necessarily straightforward, as explained earlier in the presentation. The difficulty with certain approaches considered by the government lies in the fact that the UK has no central copyright register, unlike some other jurisdictions. Certain approaches are based on having that register essentially as a starting point whereby parties can refer to something and identify certain rights, and then effectively finding out whether the relevant owner has opted out or opted in into the relevant right being permitted to be used for the purpose of AI training or not. But in a situation where there is no central register, trying to manage certain permissions can be practically very difficult. And of course, the important issue is that losing or restricting certain aspects of existing copyright protection in creative industries is very likely to result in a negative impact and creative loss to the industry and to all of us, because many creators naturally create because this is part of their work. This is the work that they've been reimbursed for, and the licensing system is something that encourages that creativity and that provides financial rewards that are due to them. So of course, any risks to that system or any lack of clarity in that regard will likely be sadly a deterrent to creative industries and a big loss to economy. I guess the wider question in that regard is, what is the ethos of AI that the UK is willing to adopt? So what are the purposes that we would like AI to be used for, and what comprises this? What sort of use of AI will be acceptable? Will it be regulated? What sort of copyright protected works should be used to assist this, and to what extent? So there is a wider ethos question, I think, that will likely determine the government's further decisions. The government has recently passed a Data Use and Access Act 2025 after much back and forth between the House of Commons and House of Lords. The Data Use and Access Act was not, strictly speaking, supposed to legislate in relation to copyright and artificial intelligence, but there are some provisions that are relevant to that aspect, further to significant insistence from the House of Lords. The main purpose of the Act is to encourage responsible data sharing in various areas of public sectors, such as health and digital verification, innovation, etc. The Act has become law in mid-June 2025, and it requires the government to report within 9 months from that date in relation to how copyright protected works are used for the purposes of AI development. And this includes also a review of policy options which were presented by the government as part of the consultation, and a progress update within 6 months from the date when the Act was passed. That report provided by the government will consider AI systems that are developed in the UK and also those that are developed outside of the UK in the context of various jurisdictional issues that this bears. And the big one, the other big piece of puzzle is Getty Images and Stability AI. We are currently awaiting judgment, which should be available at the latest in the early autumn. The case relates to various issues, starting from copyright protection, trademark protection, and jurisdictional issues which relate to use of protected works for the purposes of AI and AI generative output. The decision in this case will be very, very significant, and it will have a huge impact on the developments in the UK law on protection of copyright and artificial intelligence. There is no doubt that alongside the government consultation, this case will significantly shape the future policy in the UK in relation to AI and copyright. There are also other issues that are emerging. We've recently seen the emergence of image rights protection through copyright, for example, in Denmark, whereby individuals were granted copyright protection rights in respect of their image, and they apply in the context of use of image for the purposes of AI, for the purpose of creation of deepfakes, etc. All of these issues will be highly relevant to the future shape of AI and copyright protection in the UK. And there will be more updates in relation to all of these issues in our next video. If you would like to find out more about these issues or any other intellectual property related issues, the contact details are at the slide, and we encourage you to drop us an email or to give us a call. We have got multiple offices also in the UK. If you wish to contact us, please feel free to do so. We'll be delighted to hear from you.